One is that on the torture area, we have a robust binding torture framework or anti-torture framework. 174 states parties to the Convention Against Torture, which applies both in wartime and in peacetime. The definition in Article 1, I would say these days, is customary international law. The essence of that definition of the infliction of severe pain or suffering for the purposes of doing things such as intimidating, oppressing, extracting information or a confession or discrimination remain at the core of that. And that framework, I venture to say in the report, is stronger than the framework we currently have on violence against women or gender-related violence. There is no statute of limitations, as you know, on crimes of torture, whereas in domestic laws, including military codes, there are often time limits of 3 or 6 years after which a victim and or survivor is not able to make their claim. No immunities and no amnesties are explicit, and the penalties are generally higher than those at domestic law for rape. So the convention, you know, says that these must attract the highest penalties to recognise the gravity of the offence of torture, which is a jus cogens and erga omnes violation. The second that I think is very useful to the inclusivity to the torture framework is its inclusivity. It's not a women and girls framework. It's not in the minds, even if rape and sexual violence is also not a women and girls framework, but has become almost associated with that. So it allows all victims to be able to, in my view, speak more freely about what has happened to them and not isolate the sexual violations with the other violations, which may be all part of a continuum. Not always, but in a lot of cases, it's kind of the escalation when other forms have, for example, failed to intimidate the prisoner, has failed to break their will, then they may move to these other considered more serious violations. The third area is shame, and the report spends some time in trying to shift the shame from victims to perpetrators. And that, in a way, is about the fact that there's no shame in being tortured. We don't talk really about shame and torture, yet we talk a lot about shame and sexual violence and sexual assaults and rape. And of course, all of the people in this group, I imagine, you know, the immorality of this crime is not on the victim. It is the immorality of the perpetrator. And we need to start really pointing the fingers and exposing that level of absurdity in how we talk about these crimes. And the fourth is around consent. All these very fraught arguments about, especially rape as a form of sexual torture, these questions about did the person consent or not. Well, in torture, we don't ask people whether the beatings they received at the hands of the military officer, they consented to them. We don't ask them whether, if they're hung up in the room, they consented to them. Why are we asking them about consent when this is all part of a continuum when sexual acts are at play? So in a way, both for victims and survivors, but also investigators and prosecutors, it may free them from some of these otherwise very tricky legal questions that also allow perpetrators to, in a way, distort what might be occurring in, say, other forms of rape within the context of torture, which is one of a coercive environment and an abuse of power relationship.